Hearing in the appeal, the Queen on the application of UNISON and Lord Chancellor.
Ms. Rose.
My Lords, my Lady, I appear with Ms Monaghan QC, Mr Purchase and Mr Steele for the appellant. Mr Barr QC and Ms Wakefield appear for the respondent, the Lord Chancellor. And Mr Ford QC, Mr Keane and Mr Whitcomb appear for the intervener, the Equality and Human Rights Commission. And the Court also has further written submissions on behalf of the Independent Workers' Union of Great Britain from Mr O'Neill QC and Ms Motion. As the Court will know, in the summer of 2013, the Lord Chancellor made the Employment Tribunal fees order, an order which requires claimants in employment tribunals and appellants in the EAT to pay substantial fees to issue their claims and further fees to pursue those claims to a hearing. The order was made under a general power contained in the Courts, Tribunals and Enforcement Act 2007. UNISON has brought two claims for judicial review of the fees order. And we submit that the fees order is ultra vires for three reasons. The first reason is that we say that the fees order restricts the right of unimpeded access to justice, which is protected as a constitutional right at common law under the European Convention on Human Rights and under EU law. As a restriction to this fundamental right, we submit that the order will be lawful only if it can be shown by the respondent to be a proportionate means of meeting a legitimate aim. We say that the order fails that test, both because it violates the essence of the right of access to justice for a significant proportion of potential claimants, and because in any event, it does not satisfy the test of proportionality. So that's the first ground. The second ground on which we say that the order is ultra vires is that we say that it frustrates and is inconsistent with the intention of Parliament manifested in primary legislation, and in particular in the primary legislation which established the system of employment tribunals and the substantive employment law rights to be enforced through those tribunals. Specifically, we say that the order frustrates the intention of Parliament that employment tribunals should provide an accessible and affordable venue in which claims, particularly including small claims for modest sums and claims that do not entail giving of any compensation at all, may be brought by employees against their employers. It is in order to effectively enforce these statutory rights that the employment tribunals were established, in many cases specifically to enforce rights that the United Kingdom was required to have an effective system to enforce under EU law. So that's the second ground. And the third ground is that we say that the fees order discriminates indirectly against women and other protected groups, and that its discriminatory effects have not been shown to be justified. The third ground will be developed later today by Ms Monaghan, and my submissions to the Court will focus on the first two grounds of appeal. As the Court will appreciate, the situation has been somewhat complicated by the late emergence of further evidence, as is not uncommon in cases where the Court is required to address a question of proportionality, which has to be assessed by the Court in the situation as it is now. And most importantly, we now have available to us the fruits of the long-awaited review conducted by the Lord Chancellor into the operation and effects of the fees order. That was first produced at the end of January this year. That document is in part 3 of the appendix, starting at page MS 1773. I commend it to the Court. It needs to be read in its entirety including particularly its annexes. It's very important to the issue of proportionality, and I will be considering it with the court in some detail. My submission is going to be that when you look at the review, it lends powerful support to the submissions that have been being made by UNISON throughout the course of this litigation, that in fact the fees order is disproportionate in its effect on the right of access to justice. And in fact, what you see in the review is a fascinating tale of two narratives pulling in opposite directions, because the fees order contains two things. First of all, a significant amount of objective data, which in my submission shows the disproportionality of the effects of the order, combined with a narrative at the front half of the review, which with respect to the respondent is a self-serving narrative produced in the course of this litigation in an attempt to justify what has now become wholly indefensible. As this court will know, both the Divisional Court and the Court of Appeal dismissed this claim. In doing so, they focused exclusively on the question whether the fees imposed by the fees order made it, and I quote, in practice impossible, that was the test, in practice impossible, for a significant but unquantified number of potential claimants to pursue their claims because they truly could not afford to do so without having to forego some essential living need, such as accommodation or food. The courts below concluded that that test wasn't met because of the provision which the scheme makes for the remission of fees in certain means-tested circumstances. We say that the Court of Appeal and the Divisional Court applied the wrong legal test. Once the court had identified the fees, as they self-evidently are, as being a financial restriction on the right of access to justice, what the court should have done was to apply a classic proportionality test and not to focus narrowly on a question of bare affordability and impossibility as being dispositive of the claim. The respondent still maintains the correctness of the Court of Appeal's approach before this court. We say it's wrong as a matter of domestic, human rights, and European law. We also say that even if the Court of Appeal's legal test were the correct one, it is in fact now clear from the evidence which has become available, particularly as a product of the Lord Chancellor's review, that a very substantial number of claimants, amounting to some 8,000 in a single year, are indeed unable to afford to pay the fees and for that reason do not pursue their claims. We therefore submit that in the light of the evidence as it now is, the Court of Appeal's judgment is unsustainable as a matter of fact, as well as a matter of law. I propose to proceed as follows. First, I'm going to outline the scheme under the fees order and the statutory powers under which it was made. Second, I shall summarise the effects of the scheme as they now appear from the up-to-date evidence. Thirdly, I shall consider the legal test against which the lawfulness of the scheme is to be measured for the purposes of ground one by reference to the relevant domestic and European case law. Fourthly, I shall apply the correct legal test to the facts and explain the reasons why we say that the fees order is ultra vires under ground one. Then, fifthly, I shall identify the errors in the approach taken by the Court of Appeal. And finally, I shall develop our argument under ground two, which I shall be able to do fairly briefly because, of course, factually, much of it overlaps with the points made in relation to ground one. So turning to the fees order, if I can invite the court to take up the first authorities bundle and go to tab 3. This is MS page 2101. you have here an extract from the Tribunals, Courts and Enforcement Act 2007, which is the statute under which the fees order was made. And first of all, at section 39, a general duty imposed on the Lord Chancellor. The Lord Chancellor is under a duty to ensure that there is an efficient and effective, and we invite the court to underline effective, system to support the carrying on of the business of and at sea employment tribunals. So both the efficiency of the tribunal system and its effectiveness are to be ensured by the Lord Chancellor. Then, if we go to section 42, we see the power to levy fees. The Lord Chancellor may by order prescribe fees payable in respect of, and then there are some specified tribunals, and then at D, anything dealt with by an added tribunal. An order under subsection 1 may in particular contain provision as to scales or rates of fees, exemptions from or reductions in fees, and remission of fees in whole or in part. And an added tribunal is a tribunal specified in an order made by the Lord Chancellor. And then, so far as the nature of the statutory instrument is concerned, the court goes over to page 2106, you see section 49, and in short, both the power to add a tribunal and to specify fees for the first time must be done by statutory instruments subject to an affirmative resolution of both Houses of Parliament.
Yep.
Then we come to the fees order itself, which is in the core volume. It's at Appendix 1, page MS 372. Before we come there, just for the court's note, there was a separate order which added the employment tribunals and the EAT. I don't think we need to turn it up, but for the court's note, it's at Authorities Bundle 4, tab 49,
Thank you.
at page 3098.
Thank you.
But we do need to look at the fees order, which is at page 372.
Right.
And if we go first to paragraph 4, a fees payable by a single claimant or a fee group when a claim form is presented to an employment tribunal, the issue fee, and on a date specified in a notice accompanying the notification of the listing of a final hearing, the hearing fee. And then fees are also payable for certain specified applications and in relation to judicial mediation. But the key fees that we're interested in are the issue fee and the hearing fee.
Right.
And the amount of the fee is at Schedule 2, Table 3 at page 384. And as you can see, there are separate fees for group claims and individual claims. I'm going to principally focus in my submissions on individual claims.
Right.
And you can see that for individual claims, there are two types, Type A and Type B. And the issue fee for a Type A claim is £160, the hearing fee £230, making a total of £390. And for a Type B claim, issue £250, hearing £950, a total of £1,200. And the classification of fees into Type A or Type B is done by virtue of a schedule which starts at page 378. And the position is that Type A claims, which attract the lower level of fee, are those which are specified in this schedule. Anything that's not specified in this schedule is a Type B claim. And the intention is that the Type A claims are, in general, the more straightforward claims which use less of the Employment Tribunal's resources. And we can see the government's explanation of this. It's in the response to the government consultation on the fee scheme, part 3 of the appendix, page 985. And the decision in relation to these fees is at page 994. At paragraph 20, where you can see that the intention is stated that there should be these two different fee levels.
Sorry, where is this? You say part
Sorry.
3 of the appendix.
Part 3 of the appendix.
3-1.
I'm always giving you the MS levels.
Yes, well, my screen seems to have frozen.
Page 740 in the
I don't have
appendix.
MS numbers in my appendix, so
We never do.
can you give us both?
I'll give you both, my lord.
Very annoying, but we never do.
I know, it is
742.
740,
740, right? Okay.
paragraph 20. So this is the decision to have two levels of fees. And the objectives of that can be seen at page 1000, that's MS 1000, page 746. Paragraphs 42 to 43. And you see there that it's not an objective to deter claims. And at 43, we do not intend fees should stop claimants from bringing claims they believe to be genuine. And at the end of 43, we believe maintaining access to justice for all is a key element of the fee structure. And the allocation of the claims to the particular fee levels is explained at paragraphs 80 to 81. This is at page 1009 of the, that's the MS page numbers. Uh, 755 of the internal numbering. And here at paragraph 80, you see the actual fees.
Yep.
And what they say at 81 is this. We have allocated claims that generally take little or no pre-hearing work and usually require approximately 1 hour to resolve at hearing in the level 1 fee type. And other claims that typically take longer to case manage and where hearings are much longer, the level 2 fee type. So the level 1 claims are very short, very straightforward, require little or no case management and a very short hearing. And those are claims that cost nearly £400 to take to a hearing. Now, just to put these fees and the level of these fees into context, many employment tribunal claims are for very low sums indeed.
Yep.
And not only that, they were specifically intended by Parliament to be sums, to be claims for very low sums indeed. Now, we have handed up this morning to the court a short note, which I hope the court has. It's headed Appellant's Note comparing county court fees with employment tribunal fees in low-value claims.
We were asking ourselves that very question just this morning.
Well, I'm very happy to have preempted it, my lady. And you will see this note, in fact, does two things. The first thing it does is to identify some examples for the court of types of employment tribunal claims that are and are intended by Parliament to be very low-value claims. And then we have the comparison with the county courts. So can I first just focus on the point about some of these very low-value claims, which is it's inherent in the statutory scheme. This is an important part of our case, that this is, the whole of the employment tribunal system is geared to employees and former employees who, of course, are in an inherently unequal position in relation to their employers, having a speedy and accessible access to low-cost relief for very low-value claims. And so, first of all, we have claims under the working time regulations. Now, these regulations, of course, implementing an EU law right, and they include claims for a failure to provide rest breaks or a failure to pay holiday pay. And the court can readily imagine how a failure to provide rest breaks may not attract any compensation at all, or a tiny amount of compensation, but could be of very great significance to an employee, because over the longer term, a failure to provide rest breaks is likely to contribute to the over-exhaustion of employees. And that's the reason why, as a matter of European law, that right has been provided to employees, the overall limit on working time and the necessity for employers to provide rest breaks.
In practice, aren't they likely or quite likely to be multiple claimants for that sort of claim?
Well, that's so now, my lord, because any individual would need their head examined to bring a claim.
Yes,
so
but
the,
I mean,
so
in
the only...
practice, it's been unlikely you're discriminating against one person by failing to provide a respirator.
But my lord, the reality is that in the private sector in particular, most people are no longer in trade unions. And of course, there are some sectors where there is a unionised workforce and where a union can organise people to bring a group claim. But there are sectors where individuals have no recourse except to enforce their rights on an individual basis. And it is absolutely the case that individual claims under the working time regulations seeking relief for things like failure to provide rest breaks, excessive amounts of working time, or a failure to pay adequate holiday pay have been brought by many, many people. So in relation to holiday pay, for example, there's been slews of case law on issues such as whether or not voluntary overtime should be used when you're calculating the amount of holiday pay someone's entitled to.
Yes, of course.
And those
we've
claims...
had them here.
Yeah, absolutely, my lord. But many people who have claims for unpaid holiday pay, that claim may be worth £200. So...
As a matter of interest, I mean,
yes.
You're representing a union.
Yes.
Is it a curiosity or is it natural that the union has not produced a single actual complainant
Well, my lord,
in these proceedings? We're looking at it, I mean, to some extent one might even say theoretically, but we're looking at it generically, certainly.
My lord, we're no longer looking at it theoretically because I'm going to show your lordship that we actually now have very hard, specific, actual data. Your lordship asked me a question about why are there not genuine individuals here in relation to UNISON. And of course, there's a catch-22 here, because anybody who is a member of UNISON and to whom UNISON has ready access has the benefit of the services of UNISON. And this is a problem that is not uncommon when you are looking at claims concerning a denial of access to justice. That in the very nature of the beast, it is rather difficult to get hold of the individuals who've actually not brought claims.
But wait a minute, UNISON don't pay the fees for bringing...
My lord, they do. They absolutely do. They absolutely do.
Yes, I see.
They absolutely do. But some of the cases that are in this court's bundle include, for example, the medical justice case and the detention action case. And they are both examples of generic challenges to statutory schemes that were said to deny access to justice. And indeed, in both of those cases, the medical justice case was a straight denial of access to justice. The detention action case was saying that the fast-track immigration process was systematically unfair. And the reason why those claims tend to be brought by NGOs, such as medical justice or detention action, is because in the very nature of the type of claim, if somebody has been denied access to justice, they are not before the court.
Yep.
So coming back to the note, that's the working time regulations. Then if we go over the page, unlawful deductions from wages. Now, unlawful deductions from wages were the bread and butter of the Employment Tribunal. Thousands of claims for unlawful deductions from wages. Some of them are breach of contract claims, some of them are not, because the unlawful deductions from wages claims that can be brought in Employment Tribunal go beyond contractual entitlement and cannot be brought in the county court. And many of those, again, for very small sums. If you are somebody on the minimum wage whose employer has underpaid you, your claim may be for a very small sum of money that is very important to you. And we can see that the median award in a claim of that type in 2013, immediately before the regulations came in, was £900. And a significant proportion of those claims are for much lower sums. If we just turn up the statistics that are referred to there, it's part 5 of the appendix.
Yep. Page.
1645 is the internal numbering. The MS numbering is 1899. And if you look here, you can see Wages Act. Wages Act is a delightfully old-fashioned term. It hasn't been the Wages Act for some time, but it's a claim for an unlawful deduction from wages.
It used to be called
And-
the Truck Act once upon a time, didn't it?
Indeed, yes, your lordship's even older than I am. So,
I'm afraid that's right.
so my Lord, you can see under the heading Wages Act that 25% of those claims are for under £500 in 2013. And we've got the major heads of jurisdiction of the tribunals here: unfair dismissal, breach of contract, Wages Act, redundancy payments, discrimination. But then you have the heading Other, which is everything else. And as the court can see, the median for everything else is only £1,000. And again, 25% of those claims are for under £1,000.
3%.
Yep.
Then time off for antenatal care is the third example that we have. Women have a right to paid time off for antenatal care. Again, you're talking about very small sums of money required as a matter of European law. But if that right is denied, then the incentive is going to be for the woman not to take the antenatal care, but to continue to work, because it's likely, if she is expecting a baby, that she is anxious not to lose money. So you give an incentive to women to work rather than to undertake the antenatal care that they and their baby need. And that has obvious implications for the health of women and for the health of their children. Again, that's the reason why the European Union bestowed that right on women workers in the first place. Then a claim for a statement of the reasons of dismissal. There is a statutory maximum compensation for that, which is 2 weeks' pay. So here we have an example of Parliament capping the compensation at what for many people will be a very small sum of money. Then a very large area of work for the employment tribunals, a claim for a redundancy payment. This one of the original jurisdictions of the industrial tribunal, going right back. And again,
The original jurisdiction.
well, yes, my lady.
Training levies was the original.
Yes. So, but the sums here, again, very modest amounts, because the classic formulation, it depends on the age of the employee, but the classic formulation is you get a week's pay subject to a statutory cap on a week's pay for every year worked. So again, you may be talking about very, very modest sums of compensation. And again, we see the median redundancy award in 2013 was £2,800. Then other claims here, unauthorised deduction of trade union subscriptions, again likely to be tiny sums of money. Claim for a failure to permit time off for trade union activities, and claims for notice pay by way of breach of contract. So these are just some examples, and there are myriad different types of claims that can be brought in employment tribunals. Here are just some examples of types of claims, often underpinned by European law, often with a very long statutory pedigree, specifically designed and intended to be low-value claims that employers can effectively enforce against their employers. And the second part of this note is the comparison with costs in the county court. And as you can see, we've set out here the statutory scheme that's applicable to the county court. This is at paragraph 3. And the fees payable in the county court depend on the value of the claim and whether it's issued online, and then the amount of the hearing fee depends on the track to which it's allocated. And in general, the small claims track is used for anything up to £10,000. And we've set out here a comparison between the fees payable for county court claims up to £10,000 and claims of equivalent value in employment tribunals. And it is really quite startling. Claim up to £300, which is not an insignificant, in the olden days, was not an insignificant part of the business of the employment tribunals. £50 to take to a hearing in a county court, £390 in an employment tribunal.
Is that online or?
That's online, my lord.
And what is it if you turn up?
If you turn up, I think there's a small extra charge. I can't remember the exact figure, but
Yeah.
it's, your lordship will see it. I think it's £5 more, my lord. And then again, a claim up to £500, £90 in the county court, £390 for a type A claim, £1,200 for a type B. And you can see the other figures coming through.
They're scaled quite differently, aren't they? So it's interesting.
Yes.
As a matter of interest, when were they fixed last?
My lord, I think they were fixed very recently, actually. There was an amendment in 2014, and indeed, you'll see, 6th of March this year, your lordship will have noted that in the judgments below, in the first judicial review, there was a claim for a breach of the principle of equivalence based on the comparison between the county court and the employment tribunal. That was rejected, partly on the basis that there were additional charging occasions in the county court. You had to pay an allocation fee and so on. Those fees have now gone, so that now to take a claim to a county court, you can simply incur those two fees, unless you have some sort of interlocutory application like a claim for specific disclosure. But of course, if we're talking about type A claims, as we've just seen, claims were allocated to type A by the Lord Chancellor on the basis that they were claims that did not require case management and that required a minimal expenditure of tribunal resources.
Ms. Rose, I'm not sure you've yet explained to us how the figures for type A and type B were actually alighted on. Let's take 1,200 for type B. Was it a working back from a conclusion, well, we must get a third of the costs of the tribunal paid through fees, and then working back from that? Or can you show us more specifically how these two fees were alighted on?
My lord, it is not entirely clear. There was a general policy that users of tribunals should contribute to the costs. There was an aspiration that it should be something in the region of a third of the costs. But it is not clear to us how the specific levels of fees were identified. And indeed, they were modified at a late stage, and the balance between the issue fee and the hearing fee for type A claims was changed. The issue fee was raised for type A claims at a very late stage. And all that was said in the response to the consultation was that this was because they decided that they needed to add a bit more in for the costs at the initial stage. But again, it's entirely opaque to us, exactly the basis. Now, I'm going to come back to this question of contribution to costs, because as we'll see, in fact, the fees don't contribute anything like a third to the costs. And
No, I noticed that. I mean, have we got a clue what the county court fees contribute to in terms of costs?
My lord, I don't. But my point is not...
I think the county court gets quite near to full cost recovery.
That may well be right, my lord, because of course they have fees of 4.5% if you issue online.
Well, it's money claims online and possession claims online that fund the rest. That used to be the case anyway.
But my point is not that I'm seeking to resurrect the claim for equivalence that failed in the first judicial review. That's not why I'm showing this to the court. My point is a much more simple one, which is that it shows that you can devise a system which doesn't deter very small claims. Because one of the principal complaints that we make about this system, and really underpins our second ground of challenge, is that we say it's just entirely unfit for its purpose. Because if you have such an inflexible fee structure as this, where the lowest issue fee is £160 and the lowest hearing fee is £230, what you are essentially doing is making it uneconomic for workers to pursue the very types of low-value claims that the employment tribunals were set up to facilitate.
In other words, this isn't really an affordability point.
No.
It's a
proportionality
point. Yes,
exactly, my lord. This is absolutely at the heart of our case.
However rich you are, nobody in their right mind would punt such a large sum for such a relatively small sum.
Your Lordship has the point. And exactly, my Lord. That's it in a nutshell. And
It is a fact of life, isn't it, Mr. Rose? I mean, you made the point that some of us have been around rather a long time. When the industrial tribunals, as they then were started, they were started on the basis that there would be no lawyers and indeed no law.
yes,
That most people would make their claims in person.
yes,
They'd be dealt with expeditiously by what was then called an industrial jury
yes,
on the simplest of common sense principles.
yes.
Now, it's nobody's fault, or at least it may be or it may not be, but what has actually happened is that employment law has become one of the more complex legal areas of the law.
Yes, what your
And
Lordship says is true.
They're a lot more expensive than anybody ever thought they would be.
What your Lordship says is entirely right. However, it's in the nature of things that the types of cases that your Lordship would see, or the types of cases that I would see, are not typical of the massive claims that have historically been dealt with.
I'm talking about
by
the
employment
type of cases that one used to see.
Yes. Well, but my Lord, even at that time, it's right to say that, for example, the law of discrimination has become extremely complicated. But employment tribunals were dealing with very large numbers of very straightforward, effectively debt actions brought by employees saying, my employer hasn't paid me my wages, or hasn't paid me my holiday pay, or hasn't given me this right. Very simple, factual questions. And as we've seen from the response to the consultation, government's assessment is that those were claims that were being dealt with in an hour by employment tribunals. So, although your Lordship's right, there were still very many, very straightforward, small claims. And it is those claims which are being disproportionately shut out.
Even if they are complicated,
Yes.
it doesn't alter your disproportionality.
No, it doesn't, my Lord.
Same point.
So, essentially, we have a number of points, but the two key ones are, one, affordability, and two, disproportionality. And they are freestanding and separate complaints. So, my Lord, that is that note.
Thank you.
And my Lord, we do draw attention to the fact that even in the more complex jurisdictions, such as discrimination and unfair dismissal, many cases involve very modest awards of damages. And if I can just turn up a table that's in our written case, it's in the core bundle, page MS 106.
Thank you. Yes, I remember that.
And this is at the bottom of the page in the footnote, a table of awards under £5,000.
Yes.
And what the court can see there is very significant proportions. And this is just looking at unfair dismissal and race and sex discrimination. Significant percentages of claims with awards under £5,000. And the other thing you can see is a significant fall in the proportion of those claims after the new regime comes into effect for the years 2014, 15, 2015, 16.
The last two.
Yes, the last two.
Thank you.
And we say that that shows this effect that I've been talking about in action. And of course, for those claims, to take it to a hearing is £1,200.
Thank you.
Now, the other important feature of the fees order is the remission scheme. And that's set out at Schedule 3 to the fees order. So if we go back in the core bundle, it's page MS 399 in Appendix 1.
Thank you.
You can see at the bottom of that page is the heading Schedule 3 Remissions and Part Remissions. Now, this is actually the second remission scheme that was introduced. There was a short-lived one, which the court doesn't need to concern itself with, because this scheme came into effect in October of 2013, within 3 months of the original scheme. And there are two tests, and they're cumulative.
Yep.
So the first test you see at paragraph 2, page 402. If a party satisfies the disposable capital test, the amount of any fee remission is calculated by applying the gross monthly income test. So if your capital exceeds the amount you're allowed, then you cannot get any remission at all. And the amount of capital is £3,000. And that includes not only, you see that at page 406, disposable capital test, paragraph 3, and you see the figure for fees up to and including £1,000. The test is the disposable capital test is 3,000, and all the fees that we're concerned with are under £1,000. So that's the disposable capital test. That, in the EAT, there is a higher fee, but for the sake of simplicity, you can focus on the employment tribunals and the £3,000 capital test. And
it's defined in paragraph 5.
Yes, it is, my lord.
And 6, yeah.
And it includes non-money resources, less a discount of 10%. And then there are a number of excluded items that your lordship sees over the page at paragraph 10, including your home, your furniture, one vehicle, and so on. Now, there are some interesting features here. You can see at subparagraph I that one of the excluded items is a payment as a result of a determination of unfair dismissal by a court or tribunal or by way of settlement of a claim of unfair dismissal. But not excluded is a redundancy payment or a settlement of a claim of discrimination or a settlement of a claim of unlawful deductions from wages or an award for unlawful deductions from wages. Any payment of that nature is counted in your disposable capital. Now, this leads to an obvious problem in a situation where an employee has been made redundant but considers that they've been unfairly dismissed or suffered discrimination. Let's take a pregnant woman who's made redundant and believes that her redundancy is because of her pregnancy. On her redundancy, the employer will pay her a redundancy payment and may also pay her a sum for pay in lieu of notice. And they combined could easily amount to £3,000, or together with her savings, could easily exceed £3,000. And as a result of that payment from her employer, which is in part unpaid wages and in part compensation for the loss of her job, she now falls outside the remission scheme for bringing a claim of sex discrimination. She has to bring her claim within 3 months because it's a 3-month limitation period, consistently with the statutory intent that these should be speedy, accessible tribunals. So she's still pregnant. She's imminently expecting her child. The only resources that she has no income, the only resources that she has is the compensation from her redundancy, and she's now asked to gamble almost half of it in order to enforce her right to equal treatment. It is not surprising that that is a gamble that many people are not prepared to take. And to consider that as anything other than a severe restriction on the right of access to justice, in my submission, is a distortion of language. And to analyse it on the basis of bare affordability, can she pay the money without going hungry, in my submission, entirely inadequate.
Can I ask you, Ms. Rose, on MS 406, the table you took us to,
Yes.
the column 1 is a column of fee bands.
Yes.
Do the figures there, are the figures there the figures corresponding to the amount of a claim, or what?
No.
The amount of a fee?
That's the amount of the fee, my lord.
Of the fee. Right.
Yes. So if the fee is up to £1,000, then your disposable your disposable capital is £3,000.
Is that each fee? I mean,
Yes, it
that
is,
per
my lord.
issue, or
Yes, my lord.
so it applies separately.
It applies separately, my lord.
And you focused in your argument on on the fee band up to £1,000, because so far you've been addressing us on small claims, effectively.
Well, no, my Lord, it's not the small claims. This applies to all fees in the employment tribunals. Because the Type B claims, although in total amounting to £1,200, the hearing fee is £950, and the remainder is the issue fee. So each fee considered individually is below the £1,000 threshold.
Right.
So all of the employment tribunal claims are under the £1,000 threshold. There is a fee in the EAT which breaks the £1,000 threshold. But my main focus is on the employment tribunals.
And the other fees lower down there for what? Multiple actions, this sort of thing? What are they for? How do you get up to 7,000?
Yes, well, they would be for group claims.
Yes.
Yes, of course. Although this is a schedule to this particular order, the remission scheme is not particular to the employment tribunals. It applies to civil claims as well. So again, another of the oddities of this situation is the same remission scheme applies across the board to the county court and to the employment tribunal, but the fee levels are very, very different. Now, I made the point about the strange situation where compensation for unfair dismissal is not counted as disposable capital, but the redundancy payment or any other kind of settlement from an employment tribunal proceedings is counted as disposable capital. There has never been any rationale put forward, or not any comprehensible rationale put forward by the Lord Chancellor for that feature of the remission scheme. Now, it is also the case, looking at the excluded disposable capital, that items such as a bicycle or a laptop would be included in your disposable capital, or, for example, a piece of heirloom jewellery. And the partner's capital is treated as the claimant's capital. We see that at page 412. So if your partner has been made redundant and got a redundancy payment, that will be treated as your income, whether or not you actually have access to it. Again, this is something which particularly likely to have an adverse effect on women. So that's the capital test, and if you can't satisfy the capital test, you can't get remission under this scheme, subject only to the discretionary exceptional circumstances power. Then there is a gross monthly income test. So if you've got less than £3,000 in disposable capital, you also have to satisfy the gross monthly income test. And that's at paragraph 11. And the way that it works is that in order to get full remission of the fee, your income has to be below the level set out in table 2 on this page, and that level varies according to whether you're single or part of a couple and how many children you have. And if your gross monthly income is higher than the level in that column, then as we can see from subparagraph 3, for every £10 of gross monthly income received above the appropriate amount in table 2, the party must pay £5 towards the fee payable up to the maximum amount of the fee payable. So you then have to pay 50% of the fee for every £10, sorry, 50% of the extra income for every £10 above the minimum amount. Now, it's slightly difficult to visualise what this means in practice, but we have some worked examples. If we just go back to our written case, paragraph 27,
Yep.
page 76, MS 76. And paragraph 28, we take an example of a pregnant woman who's dismissed and has no income. but her partner has income, no remission of the issue fee if her partner's gross monthly income is £1,745 a month, which is just over £20,000 per annum, even if they have no savings at all, and even if she doesn't have access to her partner's income. Now, there are some further examples given by Lord Justice Underhill in the Court of Appeal, and your Lordships have the reference there. But that's just an illustration of what that means in practice. Now,
Where do you get the 1745 from?
it's simply a calculation based on the amount of the issue fee for a claim for sex discrimination, and then looking at £5 of that becoming payable with every extra £10 of income above the threshold. That's where that's calculated from. So there's a higher threshold for partial remission of the hearing fee because the hearing fee is a larger amount. So there's a higher threshold before you get nothing. Now, as we've noted, the second stage of the test here is gross monthly income, before tax, before national insurance. Certain social security benefits are disregarded, but apart from that, it's based on gross monthly income. That has the inherent difficulty that those who have particularly high outgoings will find it particularly difficult to put up the money, because the level of outgoings is not taken into account. So, for example, those who have a particularly high rent or high mortgage costs, or those who are trying to save for a new baby, will lose out, because the only question is gross monthly income. Now, it was in that context that the so-called notional claimants were identified by UNISON below to give examples of the implications of the application of this test for those with particular levels of outgoings. Now, your Lordships and your Ladyship have the examples at the back of the core volume, a number of scenarios that were put forward by UNISON. It's at MS page 493 and following.
Yes.
And these were calculated using, for reference point, the Joseph Rowntree Foundation's figures for a minimum of acceptable living standards. And as you can see at page 493,
Yep.
they don't contain any provision for any expenditure on clothing, personal goods and services, social and cultural participation, or alcohol. So if, again, I'm sorry to harp on about pregnant women, but if you're taking a pregnant woman, expenditure on clothing is pretty much inevitable in the later stages of pregnancy. But that is disregarded in this calculation of essential living expenses. And under this scenario, you can see that depending on whether you include or exclude those factors, a number of these scenarios either have no monthly income left over or have something like £200 a month, if you exclude things like clothing. Now, that's an illustration of the kinds of exercise.
That's the sole explanation of the difference in G, is it?
That's right, my lord. That's the difference in G, which is explained at page 493.
Yes.
Now, that exercise explains the sort of efforts that were made by UNISON to try to grapple with this test of bare affordability. And it illustrates, in a sense, how arid that test is, because to try to argue about the point at which something is or is not technically or practically or possible as an affordable proposition is a somewhat problematic question. And we say it's just the wrong approach, but in any event, those illustrations show the types of problems that can be met. Now then, the final point about the remission scheme is exceptional circumstances. This is paragraph 16 of the remission scheme. It's at page 413. A fee specified in this order may be remitted where the Lord Chancellor is satisfied that there are exceptional circumstances which justify doing so. Now, guidance has been published, and there are various iterations of this guidance. The most recent iteration of the guidance for the circumstances in which exceptional remission will be granted is in Part 6 of the appendix. It's page MS 1915. This is the 2017 guidance.
Internal numbering.
The internal numbering is the guidance starts.
Well, internal numbering.
It's right at the front of volume 6,
Right.
starting at page
61, 1661.
Now, again, this is a document worth reading because this is an attempt massively to simplify the guidance on remission to assist claimants, and the court can see that it is still head-spinningly complicated. But in relation to exceptional circumstances, the matter is dealt with at page 1661 of the internal numbering and 1915 on the MS numbering.
Thank you.
If you're likely to experience exceptional hardship. And if I can just invite the court to read from that heading down to the bottom of page 1916. In my submission, what you will see is that the focus is entirely on the question of bare affordability and hardship. You're being asked to provide evidence, for example, that you're likely to be evicted from your accommodation if you have to pay the fee, or facing legal action for non-payment of bills. Now, of course, what this provision cannot do at all is to address the question of disproportionality that we've already been considering. It has no bearing on that. In relation to the question of affordability, in my submission, it is wholly inadequate to overcome the chilling effect of the scheme on access to justice. And we can see that from its exercise. We have been trying for a number of years now to get evidence from the Secretary of State about the number of occasions on which this power has actually been used. And that evidence was finally made available to us. It's in Appendix Part 5, and it's page MS 1881. It's a witness statement provided to us August of last year, again after the hearing, long after the hearing in the Court of Appeal.
Sorry, what page was it internal?
Sorry, internally 1627, witness statement of Mr. Dowes on behalf of the respondent. 1627, my lord.
Very much. Part 5, yes.
And the relevant passage is at 1630. And he tells us that the Lord Chancellor didn't have access to information in respect of whether and the extent to which remissions under the exceptional power have been sought or made. They've now done a manual review of all paper records received in the year between July 2015 and the end of June 2016. And they've reviewed over 20,000 files. And they've discovered that 45 applications for exceptional remission were made, 30 were granted in full and 1 in part. So over a year, 31 occasions. And now we submit that that is truly de minimis in the context of the impact that this scheme has had on access to justice.
We've said against you, I suppose, that the number of applications was very low.
Yes. Because the reality is that most, what many people are doing, and I'm going to show this to your Lordship in detail when we come to the evidence that's now available from ACAS, it's now compulsory for anybody considering bringing a tribunal claim to go first to ACAS for early conciliation. And ACAS have got substantial data about what happens to those applications. Now, a proportion of them settle, a proportion of people decide that their claims were no good and they don't want to pursue them, and a significant proportion don't pursue them because they're deterred by the fees. And ACAS has identified 14,000 people in 1 year who say they were deterred by the fees, that the fees were a factor, of whom 8,000 said they couldn't afford the fees. And the reality is those people just don't pursue their claims.
I suppose the small number of people applying is perhaps testament to the fact that if you manage to penetrate what you've described as a head-spinningly complicated guidance, you'd realise there's no point.
Indeed, my Lord, because the test that's set out there is truly a test of exceptional hardship, as you'd expect it to be. Because one of the points that's made in the medical justice case, and my Lord Newberger will recall that case, was in that case it was said, oh, well, there's no problem with saying that people can be deported within 72 hours of being notified, because there's an exception that says that if they need longer, they can be given longer. But the point that was made was, well, you can't construe the exception to overwhelm the rule. And if you're saying in this case that the fees themselves are disproportionate and are having a chilling effect on access to justice, there's no answer to that complaint to say that there's an exceptional hardship power for mitigating their effect in extreme cases.
Well, I follow the point about putting everybody into the exceptional box.
Yes.
But the test that the administrators are, delivery managers, I think they're called, are they probably? Anyway, the
Yes,
test that they're asked to apply
Yes.
is whether the applicant is, bottom of 1661, realistically able to afford the fee in practice.
Yes.
You criticise that as a formulation.
I do, my Lord, yes.
Because?
Because I say that realistically able to pay the fee, in the sense that otherwise they'll be evicted or...
But why does it carry that connotation?
Well, my Lord, from the context in which it's being applied and the types of evidence that are being asked for, such as evidence that you're facing legal action.
Well, if you are threatening legal action, you want to put in the evidence. What they're also asking for is detail of income, savings, expenses, etc.
Yes, my Lord.
Anyway,
But it's ability to pay. And my Lord, that is consistent with the way that the Court of Appeal formulated the test.
Yes, quite.
And with the way that the respondent still formulates the test now.
So it's the same point.
It's the same point, my Lord. And of course, doesn't begin to address the problem of disproportionality, when people may be able to afford to pay the fees, but say the game is not worth the candle. Now, what are the consequences if the issue fee is not paid? Very simply, the claim is dismissed. And your lordships and your ladyship can see that. We don't need to turn it up. It's Rule 11 of the Employment Tribunal Rules. It's Authorities Bundle 4, tab 57, MS 3180. Is the fee reimbursed if the claim succeeds? Well, it may be, but there's no guarantee, even if you win, that you will get the fee back. The Employment Tribunal has a general discretion to award the fee to the successful party, and that's under Rule 76.4 of the Employment Tribunal Rules. And the practice is that they will generally do so, but not necessarily, for example, if the claim has only succeeded in part. And we address this, again, we don't need to turn it up, it's in our written case, paragraph 102, footnote 76, where we've cited some cases which deal with EAT fees, but it's likely that a similar approach would be applied in the Employment Tribunal. Now, the importance of that is that a claimant, even a claimant that thinks they have a strong case, cannot be certain that the fee will be reimbursed at the outset. And that, of course, is very significant when you're addressing the question of proportionality as against a very low value claim. Two other important aspects of the factual context in which the scheme operates. The first is the way that employment tribunal fees are.
It's very significant. I mean, that postulates that you know you're going to win, but
Yes.
There's a risk you may not get back the whole fee.
Yes.
But say what you say, that the sums generally recovered are so small that might mean that people said not worth it.
Yes. The reality, my lord, is that you face, at the time that you have to pay the fee, you face a number of different uncertainties. The first uncertainty is, will your claim succeed or not? That's very significant in a lot of employment claims, where the information that you need in order to answer that question is likely to be under the control of your employer. And classically, in discrimination claims, the question whether the reason for the treatment is race or sex or disability, or is, as the employer maintains, your incompetence, is likely to reside within the employer's own files. And that's the reason why there used to be the questionnaire procedure, so that you could question your employer before you had to issue proceedings to find information out. That procedure has now been repealed. It no longer exists. You have to issue your claim, and you have to pursue your claim to disclosure before you know what your chances of success are. So that's the first area of uncertainty. The second area of uncertainty is the one I've just highlighted, that even if you're confident that you'll win your claim, you may not be confident that you'll get the fee back. The third area of uncertainty is, even if you're confident that you'll win your claim, and you're confident that the tribunal will make an award to you and give you your fee back, you cannot be confident that the employer will ever pay you. Because the figures show that nearly half of the awards made by employment tribunals are not satisfied by employers. Sometimes because they become insolvent, sometimes because they just refuse to pay. And in order to enforce an award made by an employment tribunal, the employee has to take them to the county court and incur a further fee of £44. Now, it's not surprising, given that...
Sorry, when you say nearly half the orders aren't paid, you mean
yes.
not paid without county
No, I
court
mean,
enforcement, or never
period.
paid? Never
Yes,
paid.
yes, I'm going to show your lordship the figures in a little while. It's not surprising, faced with that catalogue of hurdles, that many employees are now saying it's just not worth it. It's not worth paying the fee. Now, the difficulties... I wanted to turn to that question, in fact, now, of the manner in which employment tribunal awards are enforced and the prospect of their successful enforcement. Now, this is dealt with in our written case. First of all, paragraph 21.6. Where we set out the mechanism for enforcement, that you have to go to the county court and incur a further fee. And the difficulties of enforcement are set out in our case at paragraph 102. This is page MS 107. And here, from Lord Hughes, you can see the figures. So this is a BIS 2013 study. Only 53% successful in tribunal were paid even part of the compensation prior to taking enforcement action. Even after enforcement action, only 49% paid in full, a further 16% in part, 35% got no money at all. And for completeness, over the page at 103, we note that in April 2016, new powers were conferred on the Secretary of State to penalise employers who didn't pay employment tribunal fees. And again, we see there that the numbers are very low. 173 warning notices and 60 penalty notices have been issued, which resulted in unpaid awards in only 31 cases. And what we say at 104 is that these further layers of uncertainty and cost exacerbate the chilling effect of the fees order. So it's uncertainty on the merits, uncertainty on whether the fee will be reimbursed, uncertainty on enforcement. And the other important factual context is the introduction of compulsory conciliation through ACAS. Now, your lordships should have in front of you a little statutory clip which contains some amendments to the Employment Tribunals Act 1996, starting with Section 18 of that Act. This is a new regime that came in 2014. And if you go to Section 18A, you see the requirement to contact ACAS before instituting proceedings. Before a person, the prospective claimant, presents an application to institute relevant proceedings relating to any matter, the prospective claimant must provide to ACAS prescribed information in the prescribed manner about that matter. And then that has to be sent to a conciliation officer, and the conciliation officer, during a prescribed period, has to provide for a motion for settlement. Now, there are, as you can tell from the repeated use of the word prescribed, there's a lot of regulations that have been made under this power, and we don't need to look at the detail of it. But the broad point is that since 2014, it's been compulsory to refer a prospective employment tribunal claim to ACAS and for ACAS to seek to settle it.
So this comes before the issue fee?
No, after the issue fee, my lord.
Really?
Yes, the issue fee came into force in...
No. Now that it is in force,
Sorry, yes.
you have to do
I
it
see. Yes.
before you fork out the issue fee.
You do, yes, you
Yes,
do. Yes, you do, my lord. I beg your pardon. Yes, you do this first.
Yep.
If ACAS conciliation fails, then you have to pay the issue fee. And that's going to be very important when we come to the information that comes from ACAS, because what that means is that ACAS now see every single potential employment tribunal claimant, and that means that ACAS are very well placed to assess the impact on potential tribunal claimants of the new fees regime.
Understand. Yep.
Does this mean that when we survey the Lord Chancellor's argument that the fees have had a very welcome effect on settlement, we may have to tease out whether it's the fees or whether it's this?
Your Lordship's entirely correct. And one of the flaws with respect in the Lord Chancellor's narrative part of the review is the complete failure to grapple with that very point. In fact, what the evidence shows is that there is no improvement in the rate of settlement following the introduction of the fees, but the fact that larger numbers of complaints are going to ACAS appears to be the result of compulsory conciliation. And what we have no idea of is whether you would have a more favourable outcome with lower or more proportionately targeted fees together with the ACAS compulsory system. And let me make it clear that it's no part of our case to complain about the compulsory conciliation system in ACAS.
Would you, for example, under this, get sight of your employer's records?
No. Not unless the employer was prepared to
You
volunteer
made the point earlier.
It's possible the employer might volunteer them.
Well, you might have to tell ACAS, I suppose.
It's a voluntary process, the employer doesn't have to engage with ACAS at all, and significant numbers of employers refuse to do so. And one might think, and indeed ACAS have said, that some of them are incentivised by the fees regime not to engage with ACAS because they know that the employee is over a barrel financially. And that's one of the reasons why I say that you might get more successful conciliation if you combined compulsory conciliation with a much lower, more proportionately targeted fees regime.
Well,
Now,
no penalty for not engaging with ACAS.
no, there isn't, my lord. Now, I want to now turn to the effects of the fees order and the current state of the evidence as to the effects that the fees orders had in practice on access to employment tribunals. Now, the court will be aware there's always this dilemma for an advocate. Do you deal with the law first or the facts first? And in most cases before this court, one would tend to deal with the law first. This is an exception for two reasons. Firstly, because there is significant new evidence which is not contained in the judgment of the Court of Appeal. And secondly, because in our submission, the legal framework which this court ought to analyse this case is actually very straightforward. It is a classic formulation. There is self-evidently a restriction on the right of access to justice here, and therefore that restriction will be unlawful unless it can be shown to be justified. Now, it's an oddity of this case that the Court of Appeal rejected that analysis and that the respondent rejects that analysis, and in due course I shall explain why they're wrong. But in my submission, that is the right legal test, and what's important is the application to the fact of this case. And we submit that the evidence in this case shows the following propositions. First, that the employment tribunal fees are in fact deterring very large numbers of claims. This is not in dispute. The overall decline in the number of claims since the introduction of the fees is in the region of 68% across the board. That fall has persisted over nearly 4 years now. Secondly, the fall is greater in poorer parts of the United Kingdom. Thirdly, about 8,000 people in 1 year have stated to ACAS, after conciliation attempts have failed, that they have not pursued their claims because they cannot afford to pay the fees. A further 5,000 have stated that the fees were a factor in their decision not to pursue the claim. Now, those figures are significant for a number of reasons, which I'll come back to in detail, but the court will note here that ACAS has distinguished between two different types of complaint. One, I cannot afford, and two, the fee is a factor in my decision not to pursue. The next point is...
Did they explain what the terminology meant?
They don't, my lord, but I'm going to look at that in a little more
The
detail.
5,000 are in addition to the...
In addition to the 8,000,
Okay.
yes. Oddly, it's totaled as 14,000, the reason for that being there's some rounding.
Sure.
So it's likely to be more than 5,000.
Apart from those who are sponsored by trade unions, it's a little bit difficult to think of anybody for whom it wouldn't be a factor.
Well, that's true, my lord, but it's a factor to the extent that they don't issue a claim, even though
I follow.
they have been to early conciliation and they haven't succeeded in resolving their claim through early conciliation. So these are a self-selected group of people who've got a genuine sense of grievance and who have been prepared to pursue it to the early conciliation stage. That's also a very important point. That these figures are likely to understate those who are deterred, because they only include those who take reconciliation.
There's nothing wrong with it being a factor, though, is it? I mean, unless you say that all justice should be free.
No, my lord.
It's always a factor. You may have a perfectly legitimate claim, but
yes.
You will ask yourself, is it really worth putting myself to the time, trouble and expense of pursuing this?
My lord, let's assume a situation in which your lordship has a valid debt claim
Yes.
for £1,000, and you are told that the fee for taking that claim to the county court is £10,000.
Well, obviously, that's a considerable factor, but
No,
if I were told that it was £100,
yes.
I might say, look at the whole thing, and I might still not bother. I mean, it might be sufficient
My lord,
to put me
you
off.
might not, but
If it were a free service, as, for example,
Yes.
the arbitration services, then you use it readily. Financial Ombudsman
Yes.
Service, or whatever they're called now.
Yes.
You use it readily. So, but if it costs you £100, you might say,
Yes, but the point I'm making to your lordship is you cannot say that the amount of the fee is fine, provided you can afford to pay it. Because if the amount of the fee is too high in relation to the amount of your claim, it will in practice deter the bringing of claims simply because the fee is excessive and disproportionate in that sense.
well, that's what I
And
think
that's
is
the
the
central
ultimate
problem.
question.
Yes, it is.
How much hardship, if you put it like that, are people, can one legitimately put people to in relation to the bringing of claims?
My lord, absolutely. And that, of course, is the essence of the fourth aspect of the proportionality test. Has a fair balance been struck? And I'm going to come on to the application of the proportionality test a little later, but your lordship's right that that is at the heart of it. Now, so I'm just summarising what the facts show. We've dealt with the 8,000 and the 5,000. The next point is there has been no improvement in the success rate of tribunal claims
Yep, we've seen that.
since the fees order was introduced. On the contrary, there's been a small drop in the
Yep.
success rate. Now, that's important because it shows that it's not the weaker claims that are being deterred. It's equally weaker claims and strong claims. The next point is that there's no improvement in the rate of settlement. The next point is that the decline in the proportion of claims is particularly great for low-value claims and type A claims. And that, we say, supports our disproportionality principle. And the final point is that the sums that are being raised by the fees order are relatively small. The gross income from the fees order since its introduction has been in the region of £8 or £8.5 million a year. That's less than 10% of the total running cost of the employment tribunals. Now, of course, one reason why the fees are not raising a great deal of money is that so many people are being deterred from bringing claims at all. It is a classic economic principle that if you put your price too high, people will not avail themselves of your goods and services, and you will make less money than you would have made if your price were lower. That is why we talk about a profit-maximising price, which is not the same thing as the highest price in the universe. And this is a very important point, because, and I'm going to show the court this in detail, the respondent, in the face now of evidence that a very large number of people are being deterred by the fees from bringing claims, has made no attempt at all to model the very important question, could we raise as much money or even more money with lower or better targeted fees? On the contrary, the position that the defendant, the respondent, has adopted is to say there is an inverse relationship between the amount of money in the fee and the amount that's raised. In other words, the lower the fee, the lower the amount of money will raise, and they rely on that in their response to proportionality. They say, oh, well, any less onerous alternative will raise us less money. That is economically illiterate with respect.
I haven't heard of the Laffer curve.
Yes, indeed, my lord.
Yeah.
And
Neither have I.
Well, that's what Google's for.
Okay, well, very good.
but I'm going to...
What we used to be taught to call elasticity of demand.
The elasticity of demand, my lord. And at the time that the scheme was introduced, the Secretary of State frankly accepted that they didn't have any real knowledge of what the elasticity of demand was for employment tribunals. So all of their projections were highly uncertain. They now have the benefit of experience, and they know that fees at this level have caused a drastic fall in the amount of claims. It's incumbent on them. The onus of proof is on them to show proportionality. It's incumbent on them to show that this is, in fact, the profit-maximising price. And there's a strong suggestion that it's not, because people aren't paying it at all. And, of course, the employment tribunals have very significant fixed costs, including their premises.
I can say, have the costs of the system fallen?
Yes,
with the reduction in the number of cases?
Well, my lord, we don't know if to what extent the costs, the fall in the cost of the ET systems is a result of the reduction in the number of cases. One would infer that it is to some extent. Of course, at the same time, there has been a cost-cutting programme applied across all courts and tribunals. In addition, we know that the implementation of this system itself has resulted in extra costs. Over the last 4 years, it's almost £6 million has been spent implementing the fee system.
The system is not just fixed costs. I mean, presumably you pay for the wing members of tribunals.
Well, my lord, wing members are a bit of a rarity these days.
Yes.
Are they? Okay. I'm out of date too.
But of course, that there are interesting questions. There are interesting questions that your lordships pose in relation to the question: would you raise more or less money with a lower fee? Would your cost savings? How much cost are you saving? All of these questions. My point is a simple one. None of this has been investigated by the respondent, and the reason it hasn't been investigated is because the respondent thinks that the higher the fee, the more money you'll raise. So now, turning to the first of the propositions that I just set out, the deterrent effect of the fees on claims because a significant number of claimants cannot afford to pay them. And the first point, obviously, is the drop in the number of claims. Now, The key material here
Yep.
is the review. So if the court would like to take up Appendix Part 5,
Yep.
and if we go to page 1797 in the MS numbering,
And what in the non-MS numbering?
in the non-MS numbering it's 1543,
Thank you.
paragraphs 102 to 105,
Yep.
and at paragraph 103 there's a summary of the figures, the falling claims over the years, and the conclusion is common ground at 105. The actual fall has been much greater. We have concluded it is clear there's been a sharp, substantial and sustained fall in the volume of case receipts as a result of the introduction of fees.
Yep.
So that is common ground.
Well, the 68% that you gave us is actually the respondent's figure in her skeleton.
Yeah.
Yes, yes. And there's debate between the parties over the exact level of the figures. In my submission, it doesn't matter. I do invite the court to note, though, that the fall is greater in the second year than in the first year. In the first year, it's 66%. In the second year, it's 68%. The fall is also greater in poorer parts of the United Kingdom. If we go to page 1855, we see the figures broken down for different regions.
No, and in old money, the page number is
1601, my lord. Now, Scotland is a special case because some forms of legal aid are available in Scotland for assistance with employment tribunals, so it cannot really be compared
Right.
with the situation in England and Wales.
Thank you.
So leaving Scotland out of the picture, what you see is, just looking at the totals at the bottom, that in London, the fall is 64%. In the southeast, it's 67%. In the northwest, 68%. In the northeast and Wales, 71%.
1601.
And in the Midlands, 72%. So you can see a correlation there between the relative prosperity of the region and the extent of the fall. Then we have the material from ACAS telling us that a large number of potential claimants who sought early conciliation, which failed, have told ACAS
Right.
that they didn't pursue a claim because they couldn't afford the fee. And the explanation of this material starts at 1798.
And in old money? It was
Old money 1544, my lord.
Thank you. Yes.
Now, there's a slight complication here because there were two sources of evidence available
Yep.
to the Secretary of State. One was an evaluation that ACAS conducted of the Early Conciliation Service, and you can see that referred to at paragraph 115.
Yes.
And that produced a lower figure of 3,000 people who said that they couldn't afford to proceed with the claim. But the Secretary of State concluded that that figure was an understatement because the evaluation, the figures given, didn't coincide with ACAS's management information, which was a complete survey of the figures over the period.
With the Lord Chancellor's management information or ACAS's?
ACAS's management information.
That's paragraph 120, isn't it?
Yes, it is, my lord.
Yeah.
So you can see the point.
Yep.
That the evaluation suggested that only 15%,
Yes.
so sorry, that 31% got a settlement, but the management information showed 15%. So they conclude that the effect of these differences at 121 is to underestimate the proportion of people who did not or were unable to conciliate and didn't go on to issue proceedings in the ETs. So they conclude that the more reliable information is the management information.
Thank you.
And if we then go to page 1806, which is 1552 in the internal numbering,
Yep.
there's further discussion of this. And if you look at paragraph 163,
Yes.
and then at 164, they say the management information is likely to be more accurate. And they say that the 2,500 who said they couldn't afford to pay represents a best-case scenario. Well, with all due respect, it doesn't represent the best-case scenario. It represents an inaccurate figure. The accurate figure is 8,000 on the analysis in this very paper. And we see the actual table, the relevant table of data is at page 1858.
Tables are much easier if you've got it in the typescript, you know. What's
Yes.
the old money?
1604.
Thanks very much.
Table 14, estimated outcomes of employment disputes combining ACAS management information with ACAS evaluation outcomes. So this is the respondent's own preferred methodology.
Absolutely.
So we see there 83,000 people notify ACAS of a potential claim.
Yep.
We see that 37% of them have been able to access justice, either because their claim settled or because they issued proceedings. So that's broken down into those two subgroups. Settlement, 15%, issuing proceedings, 22%. And then those who didn't settle but didn't progress to a tribunal, 63%, 53,000. Those who said fees were not a factor, and my Lord Mance will note that not everybody thinks fees are a factor. So that's 47%, 39,000. And then those who say that fees are a factor, a total of 14,000. And those who say they couldn't afford to pay, 8,000. Another reason, 5,000. And that's my point, that only, of course, equals 13,000. So there's some rounding there. So that's the key point. Now, this is very important evidence which wasn't available below. And it's important particularly in the light of what the Court of Appeal said about the state of the evidence on affordability. And if we just take up the Court of Appeal judgment, it's at MS 281 in the core bundle.
Yeah.
The only evidence, apart from the notional scenarios that was before the Court of Appeal in relation to the chilling effect of the order, was the dramatic fall in the number of claims. And at paragraph 63, the Court of Appeal, Lord Justice Underhill, sets out a long extract from the judgment of Lord Justice Elias in the Divisional Court. And if you look at, this is paragraph 60 in Lord Justice Elias's judgment, being quoted at page 281.
Yep.
He says, I suspect there may well be cases where genuinely pressing claims on a worker's income leave too little available to fund litigation. But the difficulty with the way the argument's been advanced is that the court has no evidence at all that any individual has even asserted that he or she has been unable to bring a claim because of costs. Now, we say that position is dramatically different now. And we see the same, a quotation at paragraph 64 from Mr. Justice Foskett's judgment. And it's said that at the bottom of paragraph 96 that the assessment has been speculative until convincing evidence to that effect is uncovered. And the Court of Appeal's own discussion of this issue is at paragraph 68, page 283. And it said, even though the court is troubled, there is no basis, this is towards the bottom of the paragraph, no basis for forming any reliable view about the numbers of such cases or how typical they may be, and that's an important matter. The case based on the overall decline in claims cannot succeed by itself, needs to be accompanied by evidence of the actual affordability of the fees in the financial circumstances of typical individuals. Only evidence of this character will enable the court to reach a reliable conclusion that the fees payable will indeed be realistically unaffordable in some cases. Well, now there is evidence from the body best placed to provide it, which has a statutory duty to facilitate conciliation as to the numbers of people who say they cannot afford the fees and for that reason don't pursue a claim. Now,
but then, of course, the Lord Chancellor says, hold on, they may say they can't afford to pay,
yes,
but what's the reality?
exactly. And let's look at what the government response is, as your lordship rightly identifies.
And the numbers are, I'm looking at 1604 on the chart. Sorry to be a bit slow.
Yes.
The numbers you say that fees are a factor, for whatever reason, is 14,000 of 53,000 who
Yes.
didn't proceed, is
That's
that right?
right. Yes.
So it's a sixth or something like that, is it?
About a quarter, my lord.
About a quarter. It may be, yes, about a quarter. Thank you very much.
16%, we've got it. haven't we?
It's 16 is against 47.
It's not.
It's 16 is against 47.
Yeah.
It's a quarter.
Yes.
Almost exactly.
Yes, it is.
Yeah, thanks very much.
Now, the response of the government to this, we go back into this document.
Yes, quite.
Yes, it is almost a quarter. Rounded up, so.
Page 1781 of the New Style numbering,
1781 of,
Appendix 5, page 1527 internally. So they say, this is paragraph 5, they say, we acknowledge that the ACAS evaluation of the Early Conciliation Service has identified a group which we estimate to be between 3,000 and 8,000 people who are unable to resolve their disputes through conciliation. Now, just pausing there, that is really a gross misrepresentation. It's not a group of between 3,000 and 8,000 people. It's unreliable data saying 3,000, more reliable data saying 8,000. The reality is that this is very likely to understate the number who are actually deterred, because, in the first place, there will be a proportion of people who settled through early conciliation, taking a bad deal on the basis, contrary to the government's belief, that a bad deal was better than no deal. And there will be other people who didn't even get as far as early conciliation. So the 8,000 is only the people who held out, didn't settle, but then didn't bring a claim because they couldn't afford it. So that's my submission is the floor of the number who are affected, not the ceiling. So then they say, we do not believe that this necessarily means that those people could not realistically afford to pay the fee. It may mean that paying the fee might involve having to reduce other areas of non-essential spending, or they were not aware of the help available, or thought they might not qualify for help under the Help with Fees scheme, or they may have been unaware of the Lord Chancellor's exceptional power to remit fees. Now, with all due respect, this is entirely speculative. And it's entirely speculative coming from the respondent who has the burden of proof in relation to the question of proportionality. Not only that, it is implausible. These are people who are being counselled by ACAS. The suggestion that ACAS is not informing people about the remission scheme would be a pretty serious one. There is no evidence whatsoever to support it, although it could easily have been obtained. What that leaves is the suggestion, when they say they can't afford it, well, they're talking about non-essential expenditure. And that takes us back to the slippery question. At what point does someone who say they can't afford something really mean they can't afford something? And there's no clear answer to that question. So in my submission, that evidential position is now fundamentally different.
Do you accept that some people who said they can't afford it may have been saying it's not worth the candle?
Well, my lord, we know that there are 5,000 who say the fees are a factor, but not that I can't afford it.
Quite.
So my submission would be that although there may be some who are saying I can't afford it and meaning it's not worth the candle, it's more likely that those who say it's not worth the candle are saying it's not worth the candle.
but what tests are they applying to themselves? I mean, I think the question does raise a problem. As you may well say, if someone says, let's go to lunch at the Ritz, I can't afford that. But I mean, of course you could once. You couldn't afford it every day of your life. But
Absolutely, my lord. But that's my point about the slipperiness of using affordability as a standard. And in my submission, it's not the right standard. The right standard is to look at the chilling effect of the order and to say, is the order, as a matter of practice, as a matter of reality, deterring substantial numbers of people with meritorious claims from bringing them before the courts? And if it's doing that, then it needs to be justified according to a strict standard. That's one of the reasons why we say affordability is not the right test, because you can't define it. And you can see the sort of knots that the government gets tied up in if you look on this same page at paragraph
How would
8.
the government then have to justify it? They'd have to, what, justify...
They'd have to show that the deterrence of meritorious claims was justified by legitimate aims and that the interference with the right of access to justice was proportionate.
I mean,
and that a fair balance was being struck.
It's slippery, have you? It's an inherently slippery problem, isn't it? Once you start charging people for going to court or to tribunals, by definition, it's going to deter, unless it's minimal. It's going to deter a number of people. Lots of people have lives and incomes which mean that any extra expenditure is
intolerable.
Well, is a problem. And therefore there's bound to be a deterrent effect.
Yes.
And unless you say no deterrent effect is acceptable, it's bound to be a sort of value judgment, call it slippery if you like.
Yes.
So I see your I'm not saying your criticism has no force, but to say it is slippery seems to me the whole exercise is slippery however you approach it, once you accept that there is a right to charge some level of fee.
Your Lordship's right that there is an evaluative judgment that has to be made. And what we'll see when we look at the case law is that where you're looking at a pure financial restriction imposed at the initial stage of a claim, that's an absolute bar to proceeding unless it's paid, what the Strasbourg court says is that that must be subjected to particularly rigorous scrutiny, not surprisingly, because the deterrent effect is obvious.
But rigorous scrutiny is one of these wonderful statements that sounds good, but you still end up with a sort of what you call a slippery exercise at some point.
There are obvious conceptual tools that can be used to analyse it, but they haven't been used in this case. And one of them is the one we've just been looking at, the question of what is the point at which I'd actually maximise the income take from this exercise without deterring a significantly large number of people. Now, the government didn't have the information to do that when they first introduced the fees because they didn't know the elasticity of demand. Now they do, but they've made no attempt to do it. And the reason they've made no attempt to do it is because they're applying the bare affordability test. And so it's an error of approach. It's a whole error of approach which leads them to fail to conduct the exercise that they should have conducted. Now, just before I leave this page, my lords, 1781, 1527 internally.
Thank you.
Paragraph 8.
Yes.
We see this. While there is clear evidence that ET fees have discouraged people from bringing claims, there is no conclusive evidence that they've been prevented from doing so. Now, you know, one asks the question, how bad does it have to get before you're satisfied that the evidence shows it? And essentially what the government is doing is putting forward speculation as against the evidence here on an issue on which they have the burden of proof.
Well, it's drawing a distinction between discouraging and preventing.
Yes, it is. And of course...
what do they mean by the second sentence? We've concluded that the system means that no one should be prevented from bringing a claim. Do they mean if it were if the exceptional proviso were applied properly, then no one should be?
No, my lord, I think what they mean is because there's no conclusive evidence that anyone is being prevented, ergo the scheme is lawful, because they're drawing the inference that the way the scheme is actually operating with the help from fees scheme and exceptional remission is sufficient to ensure that no one's being prevented. And we see that because later on, in a further somewhat slippery exercise, the lack of conclusive evidence gets converted into a statement that there is no evidence that anyone's being prevented.
Well, where's that?
Yes, my lord, I'm just trying to find the reference. I may have to find it after lunch because I can't find the page reference now.
We'll come back to it.
Yes,
Ms.
I'll
Rose.
come back to it. Here we are, my lord, it's paragraph 185. Paragraph 185, page 1811 in the MS numbering, 1557 internally. Although we have concluded that there is no evidence that people have been prevented from bringing ET claims.
Sure.
That's obviously wrong. And we say that the outcome here, showing the substantial number of people being deterred, is entirely unsurprising when you consider the features of the scheme, including the remission scheme, that I've already put forward to the court, and the uncertainties that a potential claimant has to grapple with in terms of the merits, reimbursement of the fee, and enforcement. Now, the response of the government to this problem is a limited reform, a proposal for a limited reform of the remission scheme. And you see this at 1840 in the MS numbering, 1586 in the internal numbering.
Thank you.
They're proposing a modest increase in the gross income.
Yeah.
Now, we say two things about that. First of all, it hasn't been brought into force. There isn't even a decision to bring it into force. It's simply being consulted upon, so it cannot affect the outcome of this claim, which is about the scheme as it is now. Secondly, of course, what is proposed cannot address the problem of disproportionality. Giving people, a slightly larger group of people, remission doesn't address the problem of the disproportionality between the fee and the size of the claims.
This looks as if it's a consultation document.
It is, my lord.
I suppose that may be, yeah.
Yes, this is the consultation. Right. So that's my first point, that there is no decision to introduce it. It's simply a proposal. So it can't make their position better than it would otherwise be.
Right.
What was the page reference to this document? Sorry.
1586 internally, 1840 externally.
Yes, the proposal's at 1587, paragraph 351.
Yes, I'm grateful, my lord. So that's the question of affordability and the evidence on affordability as it is now. And the second issue is the second point that I have already flagged, which is the implications of the fees order for low-value claims. That if a claim is worth around the same amount or not much more than the fee, a rational employee won't bring it regardless of their means. So this is not about affordability. It's about the reasonable choice that somebody makes about the costs and benefits of their own actions. And it is classic disproportionality. Now, there's an economic theory that underpins this called the theory of rational choice, which is developed in a fascinating article in the Modern Law Review by Adams and Pressel, who are, Adams is an economist and Pressel is a lawyer. And they have teamed up to produce an article which addresses the lawfulness and the economic rationality of the fees order. And this is in Authorities Bundle 13, tab 177.
Thank you.
You can see who they are.
Could we have a page?
I beg your pardon, my lady. It's page 6611.
Thank you. See, I like the new money numbers.
So this paper analyses the fees order from both a legal and economic perspective. It's a very interesting piece of work now published in the Modern Law Review. This is, I think, a proof copy, but we do have the final published version available.
Yep.
And you can see who they are from the bottom of page
Yeah, we've
6611.
seen that, yep.
And this particular point about rational choice is dealt with starting at page 6631 under the heading "The Very Essence of the Right." And at 6632, the first point that's made is a legal point. They say, actual inability to afford a fee might often be a good indicator of a particular regime's violation of Article 6. The threshold, however, is set significantly lower. If claimants' payoff structures are changed to such an extent that even clearly meritorious claimants stand to lose out financially, access to justice will be denied regardless of affordability.
Yep.
And they then cite some authority for that, and they say at the top of 6633, these decisions are wholly consistent with well-established economic models of rational claimant behaviour, best understood through analysis of the fee's impact on expected claim value. The choice whether to litigate or not is driven by a claim's expected payoffs once all costs and benefits taken into account. A rational claimant will only sue when the benefits she expects from bringing a claim exceed her expected cost of doing so, when the expected value of the claim is positive. And they set out a very simple equation there. And they point out that that can be expanded to address additional aspects, including the possibility of settlement, cost of uncertainty, and the fact that claimants often struggle to recover damages awarded. Now, they've then actually done an analysis, and they reached the conclusion at 6634 that even under the most optimistic scenario, 20% of successful unfair dismissal claims are now associated with a negative payoff, and 45% of Wages Act claims. Now, the particular economics of this are fascinating, but not central to the case. The point that I make is the much more simple one, which is that this is a basic flaw with the scheme as it has been made, that the lower threshold for fees is so high that it's inconsistent with the very statutory purpose of the employment tribunals, which is the facilitation of low-value claims brought by employees against their employers. And there's another very good example of how the Lord Chancellor herself operates this type of modelling when you look at the criteria for the award of legal aid in civil litigation. Because the whole of the civil legal aid scheme operates on the basis that in order to get legal aid, you must demonstrate that the benefits, your anticipated benefits of pursuing the claim are such that it is worth incurring the costs. And detailed formulae have been produced by the
based on the assumption that if you were funding it yourself, would
Yes.
be a rational choice.
Exactly, my lord.
Fund the litigation. Yeah.
Exactly, my lord. That's exactly the point. And that's the point that I rely on. And if we look, we can see the criteria that the Lord Chancellor herself has applied for public funding. It's in the appendix, part 4, page 1034. That's an old money number, I think. Yes, it is. The new money number is 1288. So this is from the Legal Aid Funding Code guidance on merits, costs and damages. And after dealing with the question of assessing the prospects of success, we come at page 1291 on the MS numbering 1037 internally to the question of cost-benefit.
Yeah.
Types of cost-benefit criteria.
Fundamental.
Fundamental to the code. Necessary to consider whether what is to be gained from the proceedings justifies the likely costs. Evens for level of service that don't have a separate specific cost-benefit criterion. Issues of cost and benefit are central to decision-making. And then different types of case require different forms of cost-benefit criteria. 3 separate cost-benefit tests for full representation. Every case must be put into one and only one. First, quantifiable claims. In these cases, funding will only be granted for cases which satisfy specific strict damages to cost ratios, which vary according to prospects of success. Then unquantifiable claims, where the test is whether the benefits to be gained justify the likely costs, such that a reasonable private paying client will be prepared to litigate, having regard to the prospects of success and all other circumstances. And then there is a slightly more generous test for public interest cases. And for quantifiable claims, we see the formula that's applied. It's at page 1292, 1038, paragraph 5. If the prospects of success are 80%, likely damages must exceed likely costs. If they're good, 60 to 80% must exceed costs by 2 to 1. And if they're moderate, 50 to 60%. And remember, we're talking about discrimination claims here where it's extremely difficult to estimate the merits. Likely damages must exceed likely costs by a ratio of 4 to 1. And we're told at 4.6 that that is assuming that the costs are irrecoverable.
Yep.
Now, the implication of that is that for a discrimination or unfair dismissal case worth less than about £5,000, it wouldn't meet the cost-benefit test for civil legal aid because on the Lord Chancellor's own assessment, the game would be worth the candle. And we say that is very significant when you're asking the question, is this fee structure proportionate? Given the number of claims below that level that the court has seen.
Which means, does it, that this guidance is equally disproportionate?
No, my lord, because this guidance is dealing with civil legal aid.
Yes.
And of course, in the civil courts, the fees are much, much lower for very low value claims.
There's also a distinction between a fee, which is the barrier to bringing a claim,
Yes.
and access to legal services.
Yes, absolutely, my lady. Absolutely. So our case is a fortiori, the problem that's being presented here. This is talking about the totality of legal costs. In all the submissions I make, we assume that the claimant is representing themselves. Your Lordship, of course, will bear in mind that there is no civil legal aid available, of course, for employment tribunals.
Oh, yeah. Oh, yes, or from much else. Yeah. Is that a convenient moment?
Yes, it is, my lord.
Thank you very much. We'll resume again at 2 o'clock then. Thank you. Court's now adjourned.